Hi, Tammy.
Hi.
Yeah, you passed your exam, eh? Today.
Yes.
That's great news. Excellent.
Yes,
Good show. Hi, Nicole, you there?
Yes, I am. How are you?
Good. How about yourself? How are you doing?
Oh, I'm hanging in there as best as possible.
You always say that. You're hanging in there.
Yes, sir.
So, um, yeah, I'll just start with the book so we can actually start to go through the um, so today we are going to start with the internet law and ethics. We will see if we can start today, otherwise we'll finish it tomorrow. There was another segment which we missed out. The previous class was about the surveys and questionnaires, but I'll give you the slides which has the map, more like a it's a diagram which is very helpful. If you recall, that that is what we were following last time. So I owe you those, and I'll get the opportunity tomorrow to put it together, all of it. So the cyber law, as you know, and I don't know if you've read any of it. I'm assuming that Tammy must have had at least tried the Q&As. I usually start with Tammy and ask her ahead of time if she had any questions that has to do with internet law. I wonder why this is not showing up. It may just come back up. So in the meantime, we'll start with the book. You could see that on page 517, we see a diagram here. It is an illustration of some of the important laws which play a role in our research work, somewhat directly or indirectly. It has be understood in a certain way or from certain angles. One of them has to do with understanding some of the content that we'd like to reproduce or share or build on top of when we do our research work. And the other is somewhat e-commerce parts and e-contracts, something that you normally don't interfere with unless there is a peculiar or unusual situation. If you have to do research for products and services, or you're doing market research, comparative analysis, business intelligence gathering, and so on. So when it comes to products and prices, e-commerce are the sites that you're going to go to. And there are certain legal things that sort of are be read ahead of time or to be understood so that you can actually make sure that you don't get caught on the wrong side of the law. So my computer is acting up a little bit, but thank God it's almost towards the end of our classes. It needs to be cleaned up, I guess. Anyway, so at least PowerPoint is showing up. I got to scroll down a little bit, see if I can reach those slides. Looks like it's sucking up a lot of resources out of the computer. Anyway, so continuing with e-commerce, e-contracts. So let's just look at individually all of these. In between, the cyber law that we will be discussing has to do with e-commerce, e-contracts, copyrights, trademarks, and patents. This area is more complex and requires a lot of a lot of awareness of what you can borrow or what you can use for your derivative work, as they call it. And there are issues of privacy, which obviously are something that one has to be careful about when you're doing surveys, polls, or using human subjects. A lot of privacy part we'll be discussing in internet ethics. Defamation obviously is something which has to do with, and it could be a civil law, or a part of it could be criminal law, depending on the type of offense or type of situation in the legal system, which may be created by borrowing some content which may turn out to be somewhat, somewhat a slander, or it could be something that you want to verify first before you use it. Even in use case situations where you are giving a reference to something, you have to make sure that that subject or that material is not going to be causing defamation of, it could be an individual or it could be a business. Then there are cyber crimes. We don't deal a lot on cyber crimes, but when it comes to, let me just do one more thing. I'm sorry, I am interrupting you guys right now. Let me just make sure that my recording is in order. There are two recordings we do. One is in the cloud, which is automatic, and then we have to do it locally. So I'm just turning on the software, which is supposed to start doing recording on my local machine. So let me get that going. Is that coming up or not? I think it's booting up. So while it's booting up, we'll continue. So all these we have to discuss. Now, before we get into any of these different types of laws that work within these areas, which we are looking at right now in these circles, we have to make sure that the international courts that are somewhat regulating the cyberspace are within the jurisdiction. If any law has to be enforced, or if any subject has to be prosecuted, or if any complaint needs to be filed, we have to look at different aspects of cyber law. One of them is international jurisdiction. The other has to do with the country or geographic boundaries, because they start to diminish, as the cyberspace is more complex, and it is not a piece of information that floats around the same area or same province or same jurisdiction of the court. So we have to be aware of what can be considered a crime somewhere, or be considered a legal liability somewhere, where the court can actually implement certain, you could say, certain regulations which has to do with the website itself, or the regulation which involves the users or the or others or consumers that are using that website. So all of this is something that we would like to look at, not from the point of view of crime alone or the civil legal liability, but even as a researcher, we found ourselves involved in certain litigations where we were asked to appear as a witness, or to appear as an expert witness, or where the forensics or the, you could say that the digital evidence needed to be produced. So we sort of have an idea of what happens when certain legal issues are brought to the court. I'm still trying to see if I can somehow, nobody else has shown up. So that's it. Then it's three of us. I don't think we have to wait for anybody else. So importance of cyber laws, knowledge in online research. This is important. It is just defining what are some of the areas for researchers to be careful about when they are doing their research. Intellectual property laws come into play. Online privacy is important. e-commerce, financial transactions sometimes are important as well. In any case, let's start with jurisdiction. What do you understand by jurisdiction? Jurisdiction means that a court can prosecute someone, a user or a consumer can bring about a case or go to the right authorities, prosecute someone. But again, the jurisdiction will come into play, and the court might say that it is beyond our jurisdiction, or it falls in somebody else's jurisdiction, or even some of the laws don't apply because you have to go to lower courts. Now, there are lower courts, there are city courts, which we call lower courts. Then we have courts like superior courts, and then we have federal courts. At least in Canada, this is how we have different types of courts that actually handle certain type of offenses that has to do with cyber laws. Like, for example, trademark, copyright, or intellectual property. Intellectual property includes copyrights, trademarks, and the patents primarily. So all three of them fall under the federal law or federal jurisdiction, which is throughout Canada. And then there are other authorities and other laws which actually go beyond the geographic boundaries, such as WIPO, which is international authority that actually keeps your trademarks and all that information that has to do with patents and so on. But let me see if I can show it to you. Maybe I can. WIPO database. If I want to check on the international level if the trademarks or patents or any copyrights are registered, I'm going to go to this database, which is built under an autonomous body which has authority given or imparted by different treaties amongst countries, and this is considered to be a centralized database for many countries. In fact, you could say that 90% of the countries that has any sort of protection for trademarks or intellectual property are supposed to have their records in this database. So let's suppose if I have to look for any type of, and you could see that the trademarks are shown here as there are two different kinds of trademarks primarily. One of them is actually the image or the logo or anything that has to do with the artwork that is described over here, for example. And then there is another type which is called the textual or the text trademark, which means it could be a word, it could be bunch of words, it could be long phrases, but as long as it's been used by someone on regular basis and it has created a branding of its own, those words are considered to be eligible for or to be filed in the WIPO database. Besides WIPO database, there are others which are more of the local brand or more to do with the local registration. For instance, if I had registered something in Canada through the IP authority in Canada, it would also be connected with the WIPO and automatically they will be reflected in this major database, grand database. For instance, if we have CIRS here as a word, let's see if I can find that. There are others who have filed for CIRS, but the differentiation between verifying if a certain type of wording can be used by other companies or they are not your competitors, you have to look at in what category of goods and services it is filed. So here it is different category, or it could be a different business. So still you would be able to file for it. So this is just an example. Now, as a researcher, we make sure that any diagram or design that we copy and bring, similarly, you can do verification of patents and you can do copyrights as well. When you do that, you are actually making sure that anything that you have copied, transferred, or used, or there's a derivative work that you are doing on research, or that is a piece of information which has those wordings that may end up as an intellectual property, you want to be careful about them or careful in using them, or there should be a disclaimer or a link that says that you have used it or you have a permission to use it. So that is something that I wanted to clarify. Now, intellectual property is the major part of the cyber law. The other is the privacy types, or when you are borrowing data or you're using someone's information and there is issues involved that has to do with whether or not you can put that information within your writing or your blogs that you've written or articles someone has written which you are supporting and capturing information for. You want to be sure that those privacies are not compromised, and that there is a license which allows you to use that use that piece of information within the demarcation of conditions which usually involve a non-commercial use of them, or if it is for educational purposes and so on. So there are different licenses involved, and that is also part of the privacy policy. E-commerce in financial transactions, a researcher, like I said, goods and services, if it's products you're comparing, you don't want to reveal certain patents or anything that has to do with using them for price comparison, and therefore presenting it in such a way that says that, look, this company has priced it so much and this is our price. So you don't put those kind of comparisons as a researcher. A lot of times you get assignments which are involved doing product analysis and price analysis. So product analysis means you're comparing products with any other product that is out there, especially from your consumer or within the same industry. And then the pricing is another factor which you don't want to project and specifically or explicitly use it as a reference. So e-commerce, to that extent, it does say financial transaction, but we don't do that unless we are given an assignment that is got to do with online investigative researches, where you are looking for a trail or financial trail or transactions that sort of gives an idea of what is the volume of the sales, or that information is being used in some sort of litigation. Electronic contracts and digital signatures. So electronic contracts are absolutely essential for the researcher to understand, not only from the interpretation perspective, but also understand that they are actually the contracts that are enforceable. In that sense, you want to make sure that anything that you've copied or downloaded, as an example, if something is coming from Eastern Europe and you are given a piece of information or shared some sort of database from another source, and that source has a contract that you must sign or you must acknowledge, then there are ways and means that you have to use or utilize to ensure that your side of the contract or the other whoever is the person, contractee, the contractor, both of them has used the protocols or the specification which the court acknowledges. For instance, usually the court acknowledges something that is coming from third party, which verifies the signatures. The electronic signatures have their own numbers or encryptions that you can use. The third party platform allows you to buy those encryptions and so on. So there is a whole lot of issues when it comes to contracts. So contracts online has the same implementation and the same effect and the same enforcements as you would otherwise would have when you are signing between two parties with the witnesses present. So anything that you do physically can also be done electronically, except that you need to be aware of what is involved in this and whether or not it is enforceable according to the law. Online liability like torts, negligence, discrimination, and so on. This is more of a general sort of statement. Torts is one of those things which involved criminal liability, negligence, discrimination, and so on. Defamation, on online libel and slander. So what is the difference between them? And if it is to do with online information, then you need to have that biased mindset to collect that information. Make sure these are not raves and rants or something that is intentionally created to enforce or to influence somebody's judgment, or anything that involves a personality or even a business which could result in a liability that has to do with libel and slander. Both of them are a part of the defamation, or where you are tarnishing somebody's goodwill or somebody's um, their reputation and so on. Internet crimes is something that you may be aware of, especially in the dark nets. If some piece of information is coming from a source which turns out to be a pirated piece of information that is being sold as, I think they're called RIPs, RIPs, or something like that, or some software that you've downloaded, and you have not only done the download, but you have used some sort of pirated password or anything that opens up that software for yourself, or if you've been distributing that software. So this is where the criminal liability may just kick in. The types of jurisdiction, like I said, is what is really important in internet, especially if, and so there are different types of jurisdictions, and out of so many, we are only going to look at 5 of them, which is what really matters. And especially in North America, see, entire law or the cyber law that we are right now discussing is mostly to do with North America, which includes US and Canada. So it's a mix, and there are instances where the students are very specific about what they're learning in terms of whether or not they're learning of law in Canada would be sufficient, or if certain piece of the law is only enforceable in USA. So they have their own way of, or they are very particular about it. But for now, all I can tell you is that it is a mix of both. So you have to make a choice on your own. Anyone from US can say or argue that it may be something that is prevalent in Canada, but not in US. But this is not how we have designed the course. And obviously with 5.0 that's coming next, we have made an effort to distinguish between the Canadian law and the US law. So let's just look at the types of jurisdiction, and I think I'm going to end up using the book, and let's go through it quickly. There is something we call personal jurisdiction. Let me see if I can just use the view as a single page, and so that here it is easy for you to look at. So what jurisdiction refers to is the power and authority of the government to legislate, educate, and enforce its laws. All we have to do is just remember that jurisdiction, obviously, logically, the way it is spelled, means that the power of the court to do anything or do everything that is within its enforcement area. Types of jurisdiction, there are 5 main types. Personal jurisdiction is basically pinned on a person or a personality of someone. Like it could be a group of people or a single person who may belong to a certain country, or they may have a passport which has to do with with the treaty countries, or it could be non-treaty countries. But the prosecution of someone in cyberspace as an individual will depend on whether or not that person's personal jurisdiction is can be enforced, which means can that person be called in the court? Can you serve notices to that person? Does that person has a permanent address? Is that person a resident? Is that person a legal immigrant? And those kind of things. So it is actually dependent on a person, and obviously it is a lawsuit, or it has to do with something that has caused for this person to actually respond to anything from the court. It could be a complaint, it could be a witness, could be anyone. But the personal jurisdiction is to do with the person or personality or the group of people. Then we've got general jurisdiction. A general jurisdiction is, could be anything that has to, and it is very elaborate. If you go into a definition of what general jurisdiction is, it could be anything that the court can ask you to be accountable for, or to have some sort of obligation and liability to the society, and to the type of business that you are involved in. And the jurisdiction would also depend on, like I said, it could be a federal court, it could be a civil court, it could be a family court, it could be a criminal court. But then there are two ways where you can define the general jurisdiction. One is based on the level of the courts, which could be at a city level, or city courts, or local magistrates, or a provincial court, which sometimes is called superior court, and then it can go to the federal court, or even if it is an appeal, the Supreme Court is another authority which is the final word for in the law, as far as the cases are concerned. So these are these steps, and then there are different types of courts within those courts. So if, let's say, if it is a superior court as in Canada, then you've got family court there, you've got, as I mentioned, criminal courts, civil liability courts, and so on. And there is another court which exclusively deals in IP, intellectual property, that is within the jurisdiction of federal court. But those jurisdictions are dependent on the level of courts and the type of crime that is involved, including cybercrime. So that is more general right now, from the way we are going to describe it, and the way it is going to come in the exam, if it comes at all. Specific limited jurisdiction. That means that certain courts can only handle civil liability suits. Other courts can handle the traffic offenses. For example, city courts would be responsible for that. So that jurisdiction is going to be specific to that particular type of area. Subject matter is again like bankruptcy courts. Has authority for bankruptcy cases only. And this is probably not the same in US, because bankruptcy courts are not lot of time. I don't know, I'm not sure, so I'm not going to talk about it, but I know that there is a bit of a difference when it comes to subject matter jurisdiction in Canada and in USA. Territorial jurisdiction is geographic, really, and it could be provincial, it could be subdivision, like it says, of has a jurisdiction, which means that the court system would really look at certain type of crimes or certain type of offenses within that subject matter, but based on territory. So provincial courts like Ontario, Court of Ontario, similarly, there could be a court that has to do with different states in US. So those are the territories. It can be the territory over which a government, one of its courts or one of its subdivisions has jurisdictions. So this is where the authority boundaries has to do with the demarcation of physical location where the crime has happened. But let me tell you that in cybercrime, this becomes really complicated because when you are dealing with e-commerce or doing with a website that is more interactive and deals with third party, and the clients are someone who is actually buying products, not the services, but let's say they're buying some products, then there are laws which protect consumers in a way that the jurisdiction is extended or expanded beyond the boundaries of the typical jurisdictions, which otherwise are very specific for the type of crimes and the type of offenses in that area. So territorial jurisdiction, that line sort of fades away, depending on whether or not online, and I've given you one example of a website that is doing e-commerce activities. Then there could be a transaction issue also, which involves financial frauds or finance, where the transaction involves money exchangers, or where the money laundering can be an issue. So all those are somewhat dependent on the treaties they have with other countries or beyond the boundaries. We're not talking about provinces. We're not talking about whatever happens inside of a country, but let's say there are 2 or 3 countries or more countries where the crime may have not actually uh, um, happened, but the aggrieved party or those that got affected may not be in the same country. But because your server or the website is staged or located in a country like US, and someone was defrauded in, let's say, Eastern Europe somewhere, they would be able to prosecute the owners of the website, but only in the jurisdiction of that country where that server is or where the transaction has happened. So this is where, you know, things get real complicated, and there is not a lot of recourse for the users or the aggrieved party prosecute someone locally. However, uh, well, we'll come to what happens when situations like this occurs. We will learn about that later. Um, so court's authority to determine jurisdiction. The 2 questions that normally come into play is whether the court has the authority over the subject matter. Subject matter, of course, is the type of crime or type of liability or type of offense. Second thing is whether the court has authority over the parties before the court. So second thing is the personal jurisdiction. If that person is just a visitor who opened an account or staging a website somewhere else, but the person actually has a passport of some other country, or there is not. So personal jurisdiction is another thing that would be looked at. So these 2, subject matter jurisdiction and personal jurisdiction, are the ones that the court has to determine. Even for someone to prosecute anyone else in the cyber world, they have to establish that sort of jurisdiction. Normally, companies who are internationally well known, and they have their servers across the globe, like Amazon.com, like you know, even Google. If anyone has to sue one of these companies, then they have to, under the law or under the sort of privacy policies and disclaimers and everything else that is there, there is a mention and a clear mention of if somebody has to go after or sue someone, then this is where they're going to find the contact. This is where their jurisdiction is. This is where their servers are. All that information is revealed and is presented. If you read through carefully in these statements they have on the internet, you would find all, and plus they have their local presence as well. Personal jurisdiction, it is giving you more detailed account of what it is, and you would get a question on the jurisdiction that mostly the type of question I've seen is to do with personal jurisdiction. And then there is, okay, so we'll continue with that. So personal jurisdiction is most important. So I would advise you to read this one. Never mind anything else. In this section, I have seen questions coming from this part quite often. So I'm not going to read all of it. I've given you an idea of what it means. Then we're going to go to the next part, which is borderless jurisdiction or international jurisdiction. Here, the litmus test is what we call the state's long arm statute. Long arm statute simply means that the minimum contact rule is applied, which means that whoever is involved as a person, as a company, as a business, how much that person has to do with, or how much of the offense or the liability that is being claimed uh, has a part or has a direct involvement of that person or that business. Like if I say, for instance, if I'm in California and I am visiting California, I did something that was a crime, or I did a traffic violation there, but because that car that I'm driving belongs to me and that offense is in some county inside of California, while I'm actually living on the East Coast somewhere in New York, for instance, then for me to actually go and challenge that sort of legal situation in the court would mean that I have committed something in that jurisdiction of that county in California. So I have to stay there, get the date from the from the court, and attend the court over there. I don't have to have somewhat a counter facility somewhere in New York that would take care of my offense which I've committed in that county. So the minimum contact is if I had anything to do personally, directly within the jurisdiction of a place where something has happened, I am actually my minimum contact test says that I was physically there, I touched it, I did something. So this is where the jurisdiction would be. When it comes to borderless jurisdiction, the crime, the offense, whatever has happened, I have to deal with it in that area. And let's look at how it is read. The law allows a state court to obtain personal jurisdiction over an out-of-state defendant as long as the defendant has some connection with the state. The test to be applied in this regard is called a minimum contact test, where it is determined whether the out-of-state defendants has certain minimum contacts with the state and establishing that jurisdiction does not offend the traditional notion of fair play and substantial justice. So before getting confused with this definition, just grasp the idea that depending on how much of your involvement, if you're directly involved, if you're party to that offense, then wherever this offense has happened becomes your area or for the court to establish the jurisdiction. And this is where you have to report and attend the court. Now, website classifications. In deciding that personal jurisdiction was proper, the court established sliding scale approach to classify internet websites, which means that the court also is confused. At the moment, I see that this is happening a lot. Jurisdiction has not only become a problem, but it has become a situation where certain contracts or certain attorneys take advantage by building in some caveats that defines the jurisdiction on its own, especially where the contracts are to be executed versus the contracts that says that certain crimes, if they happen or there is a breach in the contract in another state, then the prosecution or that offense will be contested in that particular state where the contract was signed. So all these are put together in such a way that it establish a jurisdiction which is of more of a convenience to the client, and this is what you end up signing. But anyway, for now, let's just think what is a sliding scale for the court to decide the level of offense or where the prosecution can be done based on the type of website. So let's just look at those types. Sliding scale simply means that where the weightage would be higher, or where the probability of the nature of the crime can be prosecuted successfully, as the jurisdiction is pretty much in favor of or not favor of, depending on the sliding scale, and indirectly depending on the type of website we are talking about. So if it is a commercial website, the court defined commercial website as those by defendants to enter into contract with residents of foreign jurisdiction that involve the knowing and repeated transmission of computer files over the internet. Commercial websites are used by defendants to transact business, and in these situations, personal jurisdiction in the foreign court is always proper. So let's suppose if you have a website that is somewhere in Eastern Europe, in Estonia, and this is where the software is being sold as a downloadable file, as an example. Even though that download is done in United States somewhere, but because the server was in Estonia, it doesn't mean that the jurisdiction would have the applicable laws of that country where you have to physically go and sue them. If the crime has happened in such a way that involves downloading a file, it is a commercial website and for which you have made the payment, where the money is gone, and your stuff where you're getting wrong sort of, or there is some fraud going on for the software that you downloaded, then from the US they have a mechanism that the court would send an order that is going to be sent to, first of all, it's going to be sent to the establishments which actually are responsible for domain name. This is not mentioned in any of these content pages that we are going through right now. But just to give you an idea, that it starts with the registrant of the domain name where you file the complaint, and simultaneously you file the company through international authorities which are responsible for issuing the IP addresses globally. And then, of course, they know what to do after that. What we are concerned about right now is a crime that is not happened actually at a place where the server is or where you are getting your goods. In this case, downloadable file means that it can be downloaded anywhere. There is no physical movement of goods, or it is no tangible goods involved. So in such a case, the commercial website means that the users or the complainant can report it to several different places, and basically they will act as if they are preliminary to the court, or preemptively they are going to make register that complaint. And there's a lot of complaints coming. For example, email servers, a lot of people do spoofing, they do phishing, and all kinds of softwares are being sent, and there is mass emailing, spamming, and so on. So those servers may be somewhere else, and they are the ones who are flooding your inboxes and spamming and all that. And there is a way in which the international association and organizations would treat that server as a spammer or would have a bad reputation. If you are to do any verifications of email sources, you would find that these softwares or some of the companies that are available online would do just that for you, to find out well the reputation of those servers that are transmitting that piece of information. So the servers are well known and they're tracked through the IP addresses. They have a name of their own. For them to exist on the internet, they have to be identifiable. And so that gets affected. So this is what it means. I explained a lot more than I'm supposed to, but this is where the commercial website and sliding scale means that there's a higher probability of you as a user being able to successfully deal with them. Passive websites are not as active, or they could be static pieces of information and they don't change the content much often. It's not interactive. So the sliding scale on this one could be, that no harm done, no major issue, unless it is slander, libel, or something that has to do with defamation. But still, you can send a notice to certain agencies like Google, could be one. If the website is appearing in Google search, you can always, find means of communicating with them. Some people are in the business of doing brand management or reputation management on the internet, which means if any of your photos um, are being circulated without, or anything of yours that is being circulated without your permission, you can ask them to make sure that they're cleared. Especially the politicians do that, and they charge a lot of money, and they're responsible for getting those pieces of information out, especially in social media. So um, anyway, we are talking about passive websites. So the court defined a passive website as one in which the defendant has posted information that is accessible to internet users and does little, this is important, does little more than make information available to those who are interested in it. Passive website alone is never sufficient grounds for exercise of personal jurisdiction. So personal jurisdiction, what they're trying to say is that you have to actually prove damages. You have to prove, a dilution of goodwill, or something that is defamatory, or it is affecting you, or it can be quantified quantified in terms of money or losses, or you can actually file a claim which would precisely be able to quantify the amount of money that you've lost. So passive websites normally don't do that. If they do these, the test is, like I said, all of these elements have to come into play. So it is not a rule of the thumb, but passive websites generally don't get involved, or there's not much that passive websites would result in, getting um, favorable outcome. Um, Active website. This refers to defendants entering into a contract with residents of a foreign jurisdiction that involves knowing and repeated transmission of computer files over the internet. This type of situation is considered as a ground to exercise personal jurisdiction. It is similar to commercial website. An active website is somewhat similar to commercial, even if we don't have to divide it into all these elements. Active website is anything which is interactive, involves sales and purchase of goods and services, including downloads or movements of stock or shipment of stock, where the transaction involves an exchange of money. So these active websites, of course. Interactive websites, where user exchange information with the host computer. In the case of defendants, interactive websites accept personal determined by the level of interactivity, commercial nature of exchange. So interactive website is the middle ground between commercial and passive. The code defines an interactive site as one where a user can exchange information with the host computer. I would say that interactive websites can be, chat websites, forums, could be consumer reports where the consumers are actively placing their comments. It could be any of the websites that are responsible for reputation or do consumer rating, or so the consumers do rating for the goods and services and so on. So they are more interactive, where one can participate, leave comments, and so on. So those are more interactive websites. Um, let's go to the next topic, copyrights. In simple terms, copyright is defined as a form of protection given to the authors. Here we are getting into the IP zones, intellectual properties. In this, as I said, copyrights, trademarks, and patents is what we will be discussing. So copyrights is any piece of work, as you can see, that is really original work that is specific, can be specifically identified as something that an individual has worked on, or all these things like literally dramatic or dramas, poems, artists, and so on. Thing about copyrights is that you have to understand that there are few laws which allows you to use certain information or pieces of information under the GNU we call public license. There are different types of public licenses. I wished I could show you. Let me just get to the public licenses. I'm going to do Control F because I know GNU is better explained in the previous chapters. I'm going to see if I can find it for you. Okay, here it is. So the type of licenses that you have to look at, and most of the information that is out there on the internet um, is available under GNU or GPL. GNU is General Public License, basically, and it is widely used for free softwares. GPL General Public License, but let's see what it is. Let's just because I have to also go through this to see what it actually means. So is a widely used free software license which guarantees, and by the way, this is in which chapter? I think it is in module 2. Yeah, this is in module 2, Internet Research and Research Methods. Let's just start with free information and copyright. See, I remembered, and that is good because this is more important information than, because see, when I look at the internet law in the book, I don't see a huge section or lot of explanation in there. It's just, similar to what we covered in the research methods and methodologies. Not a whole lot of information, but some examples and some of the definitions are there. Because we don't want that to become a huge topic, already about 500 pages. But important is to understand the concept and be able to apply it as a researcher. So that's why I've taken you back. It's in a reverse gear, taking you into this section. I'm going to need a few minutes to come back and continue with this. This is an important topic. Everything that has to do with intellectual property goes hand in hand with the research work that we do, and more often we end up advising or putting a disclaimer for the client in our research report. So we'll discuss this a bit more. Okay, so Creative Commons is one of the common licenses that you will find online. And usually this type of license is giving you the option to use that work or use it to build some work on top of it. And this is what we call Creative Commons, but it is actually authorized by the author himself or herself. But there are always some conditions attached to it. Normally, I think I mentioned, but usually it is the conditions that says that you are not going to use it for commercial purposes, or you are not going to claim it as your own original work. And the third element in Creative Commons, as far as I remember, is that you make sure that that license does not authorize you to give what you call, what is the word used? Mm, you don't actually pass on that work as attributed to somebody else. So if you are going to even use the name of someone who is not the original author, even if you have copied it from a third-party source, that is going to be an offense, and you have to verify if the author is named properly, or you have given the you have given the reference to that author's original work. So these are some of the things that come in with the Creative Commons. And then you have other type of softwares that are GNU and GPL, but we have used it with reference to the software However, you can use it, or you can just look at it from the perspective of what it stands for. So it is not really only for software, just so that you understand. The GNU public licenses, or GPL, is a widely used free software license, but you could think of it as a general license for any type of information, which guarantees end users the freedom to run, study, share, copy, and modify this, the I guess the content or whatever the information you are using under this license. The only caveat in GNU and GPL is that you don't, if it is something to do with software or it has to do with the original work, you don't want to modify the version and make it your own. Compared to Creative Commons, the GPL and GNU does not allow you to change the wordings in it. This is the only major difference, even though it is also authorized, or the author has consented that people can use it, but usually it is for education purposes or for the purposes that sort of does not involve a commercial use of it. Then lesser general public license is another kind, which we call LGPL. It is exclusively used for softwares, free software. The license allows developers and companies to use and integrate softwares under GPL. Okay. BSD is another type of free license. Is a class of extremely simple and very liberal license for computer software that is originally developed, whatever. A good example is Linux. So it is with reference to the software, but wherever you see the word LGPL, BSD, GNU, GPL, or CC, and there are specific type of icons that they use, or the symbols that they use, to make sure that you don't miss it. So you may want to read that in case you are borrowing information from here. I'm going to go back to where we left. We were doing copyrights. By the way, did you know that you don't have to register the copyrights anywhere? If you have actually created something and you have a copy of that, or you have emailed it to someone, or you have something that is dated, it is considered to be your intellectual property or the copyrights. The other thing that you can do is you can copy your original work, put it in a CD, and there are third-party companies that actually keep that as a, they work as a custodian of your record. And being a third party, they're given sort of, they have this ability to testify that this is your original work and this is when you submitted it with your date and timestamp and everything. So that is another way that you can actually register, besides registering copyrights through some other associations or the copyright office. All you have to do is simply pay them the fee, tell them what the title of the subject is, or the whatever you are writing, you sort of explain what it is about, and that's all the information they require. I think they charge like $50 or $100 for registering the copyrights. It's important that you keep copies of that and you have a record which is digitally, recorded somewhere. Another definition states copyright provides an author with a tool to protect work, okay, use exploited by others. The owner of copyright's work has the exclusive right to reproduce it, prepare derivative works, etc. Not much here. Copyright, some straight facts to note. This may be important. Copyright protects the physical expression of the idea. So what constitute copyrights and what could be different things or different, specific type of work that can be copyrighted. And these are all bullet points. It says, copyrights do not protect ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. So what does it mean? It doesn't mean that you cannot, patent your procedures, processes, systems, methods of operation, and so on. You can always go for copyright. There is another way for you to preserve that. These are, whatever is goes into the trademarks and let's say patents are not exactly the same as copyright. So you have to make a distinction. If you think that some procedures or processes you have created will have copyrights, it won't have those copyrights. Unfortunately, these are considered to be methods and different processes that needs to have a very particular patent or even a trademark that says that this is a process which involves certain type of writing, certain type of images, certain, sort of anything that is an artwork will have to be a trademark and not the copyright. The copyright owner is the creator of the work, that is author, composer, artist. And so this is the kind of work that you can use as for copyright reasons. The employer becomes the copyright owner. This is very important to understand that anytime you're doing research and you have some material you have borrowed or you are using it as a piece of information that is getting money for you, that piece of information is actually borrowed, then you have to give a reference where you got it from, which is, the data source that we talked about. It has to be authentic, original, has be credible, and so on. So all of these are there, but most importantly, you also have to mention if you have bought that information for a price, or if there is an agency or a third party that actually sells that information, and that legality of that is not your headache. It's for the subscription company or whoever is offering you that data or that piece of information is responsible for it. Then if you are working for someone or there's an agency where you are a copy editor or copywriter or someone who's collecting information for your copy for your employer, then under the contract which you originally sign as an employee includes certain sections or certain areas in your contract that are exclusively saying that anything that you collect or mine, if you're doing mining or curating any kind of information, you have to know that it is actually being now, that collection is done on behalf of your employer. So it doesn't belong to you. Copyrights protection is automatic at the time of its creation. I explained that to you. Both published and unpublished works are protected by copyrights. Correct. So there could be work that you have created, but you have not published it yet. So it is your copy, and supposing somebody steals it from you or it gets leaked out before being published, that is also your copyright and you can claim that. Copyright is easy and free to be freely transferable. It is very easy to authorize someone to use your work as opposed to trademarks and patents, which are most difficult. In fact, patents are very difficult to transfer and it requires a lot of paperwork and legalities are involved. But copyright is much more easier. We don't have to worry about these references. Okay, so forget about them. All we have to understand is what it means, with the headings that that I'm showing you right now. Copyright infringement. This is coming from USA, I think, the Copyright Act 1976. That is US federal statute reference. The infringement. What is the infringement exactly? So if the exam question comes, which I've seen before, is that they're going to just write this statement or a definition and say what it means, or, is it true, is it correct or incorrect? So what is copyright infringement? It is when someone other than the copyright holder copies the expression of work. Okay, so nothing very complicated there. Copyrights and owner's rights. The right to reproduce the work. Copyrights and owner's rights means that you are the author of it, and what is your right as an owner who owns the copyrights. The right to reproduce derivative work, you can create, distribute your work, publicly display, performance rights. So you can basically allow for your work to be used by anyone else, but for you to have the rights, you can do all four of them, which means the public display you can do. If you don't have the copyrights, you can't even, put it out there on the internet and claim it as yours. So, display obviously is important. You have to mention where it's coming from, if it is yours or not. There are a lot of people who write articles in our research. This is a big dilemma where we see that the author's name is not mentioned, or the date is not mentioned, or some of the articles just talk about, or it is a business or a portal that has used somebody's work. We can't even tell if it is original work or not. And the other reason is that why they do that is so that they can use the same story, reword it, and then republish it. Or there is an article they feel that they can republish it at a later date, just to fill in. There's a lot of stress and a lot of pressure on certain companies to keep producing articles or keep generating content for their website to look fresh and to have their users come back, return for the returning users to find new things. So they keep recycling the same articles as well. So be aware of that. Mm. Uh, Forms of copyright infringement: direct infringement that takes place when one of the exclusive rights mentioned in the copyright holder is violated. In other words, direct copyright infringement happens when the author's exclusive rights, such as the right to reproduce a work, prepare derivative work based on it, distribute copies of it, etc., are violated. So like it says, direct infringement, of course, if you have the original work in your hand and you are the one who is actually presenting it, reusing it, making it into a derivative work, it is a direct infringement. That is like it is not going through anybody else, or you have not passed on that altered or changed work to a third party. So it is a direct infringement. Contributory infringement. So these are just terms that you just, sort of get a sense of what it means. Better for the exams and for you to identify with. So contributory is this type of when the liability or the responsibility of the copyright infringement is imposed on someone who is not involved in the infringing activity but contributed. So if I do something that changes the original content, and I use the original work and pass it on to somebody else saying it is mine, or for others to use or give others permission to use it, that's when I'm contributing to the infringement, and that we can call contributory infringement. Vicarious liability, this comes when you are not exactly really responsible for the copyright infringement, but you have used that work without verification, or you have used it with good intent, thinking that it is originally given to you, where you assume the authority of distribution, when in fact it is an infringed piece of work, or altered piece of work from the original, or the author is using someone else's work and passing on to you, and you in turn passes on to somebody else. So that is vicarious liability. Some examples of copyright infringement. Copying, this is important for you, of course, if you are to use somebody's pictures, like copying a picture to use on a brochure or a website. A lot of times you would find that certain stock photos that you download, they are considered, well, they have certain restrictions on uh, how you are able to use it. Even though you've paid the money for it, but it may not give you exclusive rights, or it may not give you rights in the print format where you can use those photos for putting it on your website, but cannot be printed or cannot be used in any kind of print work. You have to read through carefully, because what you will notice is that certain type of licenses that you use for stock photos are less expensive and others are more expensive. When you look at the more expensive one, you will find that those photos, if you have to use, in any other way besides the way, besides how it is stated for its use, you probably will have to pay a lot more money. Printing and selling copies of a book without permission, okay, making unlicensed copy of DVDs and selling them to public, distributing copyrighted music on the internet, breaking digital protections on software to use the software. So one of the problems that you will face, especially downloading certain softwares which are easily available on the internet, but turns out that they've been passed on to so many different websites, and it has also got a kind of a kind of a password which is generic, yet it works, or somehow the vendors have figured out a way to break the code for anyone to use it, and they eventually end up selling it to anyone. And it is distributed extensively, especially in third world countries, where the privacy and the infringement laws are not as strict or difficult to implement. You will find yourself getting into this zone of downloading something, especially the softwares. Even if it is movies or videos of any sort, you have to be careful. In the social media situations, we are running more and more into this kind of problem, because sharing some sort of softwares or even pictures or any artwork, anything that has to do with intellectual property, is freely available, because one person buys it and shares it with so many others. So this is where you have to be careful. Copyright infringement on the internet, one of the things that are involved in copyrights infringement is piracy of content. The illegal reproduction and distribution of copyrighted material, fine. So we understand what privacy is. But the privacy policies, in my opinion, if you are doing any kind of search or using any kind of website to download material, you would find these this is piracy policies, but the privacy policies or the use of their material or downloading the material or using their website in any other way except what is described in their terms and conditions could become a problem. If you get to read terms and conditions, generally understand what is involved in it, at least take an example of one website to get an understanding of what it contains, you will find that there are so many elements of um, uh, the legalities that are described for as piracies, or as the disclaimers, where you have certain rights and you don't have other rights. So you have a general idea of what terms and conditions, and they're pretty much similar if you are using e-commerce site. It's similar if you're using, or another site which could be a services side of a, let's say, you know um, a legal profession, or it could be any of those sites which typically are standard or in the same industry. You will end up reading through those terms which are similar to all those that are comparable or similar websites. So just to get an idea what is involved, you may want to read terms and conditions. And when you have to borrow the information, or if you have to um, download something from there, you want to be able to check and see. So piracy is obviously is not difficult to understand. This nation can actually help build trust with the user and so on. So the privacy is something. Why is this using privacy here and it is using piracy? There is an error here, by showing that you value their privacy. Besides, national laws require you have agreement third parties privacy. I don't know. This is mixed up. So this is a problem here. I've just noticed it. So let me just see if I can highlight this. Okay. We need a correction here. We are talking about the piracy, and we are talking about piracy in terms of copyright infringement. Then caching of web pages, this is another phenomena which is very common. Even the Google search is using the cached pages. They're not using real pages in real time and they're bringing it over to you. They're caching the pages. What caching means is it is a temporary storage which is keeping those web pages there, and these are available, but they are not actually pulled from the original source. They're copied and placed as a temporary file. So there is an implied license attached to it, which means that caching of the page and means that you can actually capture something, keep it in your folders or in your bookmarks or in your files somewhere, or you can download that content and store it on your computer. But they have some implied implications or implied laws that sort of gives you limited or allows you limited use of those pages. There is an implied license to view containing copyrighted, where any cache content is deemed to have such license unless they opt out of the following. The user provides an option to the author to opt out. So if you look at the Google search, I don't know, let's see, internet research specialist. Let's just look at this and see. There is a word. See, when you look at, if you click on this arrow, you see cached pages. When you click on this, it says cached pages. All of these are cached pages. What does cache mean? Cache means that it is temporarily borrowed. It is not taken, it is not owned, but it is used, or it is used over and over again, or frequently used, but not for individual, not as an individual who is gaining the benefit out of it, but it is actually something that is there for convenience. So those are the pages that are collected and cached. So Google, as you can see, does a lot of caching of these pages. Linking to other websites. Now, this is another type of infringement. Linking is when a website user visits another website, another location by clicking on, let me get rid of this, on live word or an image commonly referred to as link. This linking may undermine the rights of interest of the owner. Now, I don't know if you noticed on the web pages, if you have a website that you own, and on that website you're showing as if it is your own original content that is displayed in there. What it is doing is that it is linking to other website, basically showing, let's say, published articles, but when you click on it, it takes you to another website. Basically, you are giving a very nice look and feel of it with the picture and the topics, but when you actually allow for the user to click on it, for it to navigate and open up in a big, large page as a complete story, for instance, it would not open up on your website. It would actually take you to another website. So there are different types of linking. One is called deep linking. Uh, deep linking is something where you are showing the wordings, where the wording says X, Y, and Z, and X, Y, and Z is actually a hyperlink. So we also call them anchor links, where there's a whole text, it's a wording, it gives an impression as if it is a statement or some heading or caption. When you click on it, behind those wordings, there's a hyperlink is going to link you to another website or another page. Inline linking is when you are going to, you remember when we opened up the source code by right clicking, saw the HTML, all that code that is there. Some people capture some of that code and insert it into their own website, so that certain things like certain icons, certain type of information, especially the layout, the colors, and the look and feel of it is actually copied as a code. And then when they put the code in the website, it starts to simulate as if it is exactly coming from your site, when in fact you have borrowed that code and you have installed it or programmed it into your HTML code, which is for your own website. Some people do that, like YouTube, for instance, as an example. Some people borrow that totally from another website or from the YouTube directly, and then try to display it on their own website. What voice is not coming through? Nicole, there? Nicole, can you hear me?
Yes, I said it sounds glitchy.
The voice?
Yes, at least on my end. I don't know if anybody else is experiencing that.
Yes.
Yes, I did too. It's kind of breaking up a little bit.
Let me try something. I'm going to try to put I'm going to put the external speakers and see if that would work. Hold on, give me a moment. Today, I think there is a problem in my computer. I had a problem with the video also, with my camera. So let me just try to fix it. Hello, say something, Nicole, say hi or something. Let's see if it's
Bluetooth connected.
How about now?
It sounds fine now.
It sounds what?
It's fine. It sounds good.
Okay. So we'll just continue then. So inline linking, do you understand? It is embedding the code, which means the HTML, like let's suppose I go on a website, any website like this one. Let's go to mine. And on this website, if I do my right click, let's say this is the home page. So if I have to do inline linking, this is what I'll end up doing. I will go right click, open up the source, and then capture, for instance, some of the code from here, just copy it and put it on my website. Now, supposing I just want to copy this picture right here, this image, or I just want to copy this function, which is opening and closing. As you can see, it just opens and closes. So this is an automated script, but it has to do with HTML code. And it is visible to me if I do right click and go source code. Another way that I can see the area or the code is that I do inspect on the right. I don't expect you to learn this. This is just to tell you what I mean or what that inline linking means. So let's suppose it is an area that I want to copy, or some image I want to copy. Supposing I want to copy this. If I go here, it will tell me, let me just put my cursor on this. So I know that it is coming from
stressed, sleep deprived, and time starved.
Let's just do this one. This is the element I want. So it is going to highlight the source or this element and tell me that where it is coming from. And then what I do is I know that this is what it is. And I can go and look at the elements and find the code from here. I copy it and I paste it in my website. The likelihood is that the same sort of image or everything that is written here as static text will appear on my website. So I'm copying the code. Okay. So this is what inline linking is. Let's just go back. Framing is another function of how people steal information or use or infringe the copyright. What we do is that we create, hello, 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 you there? Hi, can you hear me?
Yes.
Okay. Yeah, something wrong with my computer. Still one more class to go, and it's acting up. All right. So framing means that if it is my website, supposing that this is the website that I have, and I am displaying somebody else's content on my site. For instance, if this video is actually on YouTube and it is playing on my website, I can do that. It is called framing, which means that from the designing side or from the back end of how the HTML is coded, I'm going to embed a code that is actually displaying whatever is in the original website. Not that I'm stealing it directly, but I'm displaying that information on my website as if it is borrowed in the same at the same time. While it is also displaying on the other website, it is being played on my website, like this image, for example. Or we could say that this video, let's suppose it is on the YouTube platform, and unless it is my own personal account and it is my own personal video, I shouldn't be displaying the videos over here. In fact, we got into trouble because of this, because in the knowledge network we used to have an area we call videos. Now if you click on it, it shouldn't be showing up. It says coming soon or something like that. It's not going to appear. That's because there were certain videos which were playing on this site or on our website, even though they were hosted or they were physically present on another server. There were a few of them that we had a problem with, so we had to actually stop using it. That's because we were doing framing. Okay, you understand that, right? All that I'm talking about. I know it's a little bit technical, but how else can you get to know what it means unless you know, it is explained from the technology perspective, because it's all got to do with online content that is there, which we are using or we are infringing on the copyrights. Linking to infringing works. The situation changes when knowingly linked work that infringe somebody else's copyright, like pirated music files. Well, this is contributory copyright infringement, where we are basically linking something which we have copied and downloaded on our website and playing over there. Fair use is important when we are talking about GNU license, GPL, AGPL, and CC licenses. Fair use is the word that they'll keep using. What fair use means is considered as the primary defense to copyright infringement. You might get a question, what could be the primary defense or could be the main defense to copyright infringement in case you get into trouble with the infringements. So the fair use is considered. What is fair use is also defined as the privilege to use copyrighted material reasonably without the owner's consent. In other words, fair use allows the user's use of another's work without approval for purposes such as criticism, comment, news, reporting, teaching, and research, and could be satire also. You know, could be piece of work which is not really out there to make money from or use for commercial reason. So the fair defense could be, you know, you're criticizing something, it's a comment, you're using it as a comment, you're using it as news reporting, and so on. So you have to have that defense available, and that defense can only work if you are able to prove to the court that the purpose and character of the copywriting, including whether the use is commercial or is for non-profit educational purposes. Nature of the copyright work, for example, the nature of the work is such that it can be used as a reference. It is an innovation or a breakthrough technology which has already been published in the news So nature of the copyrighted work is important, including pictures, videos, and so on. If it is an illustration of some sort, which is a common knowledge, but it is presented in a way that, you can use it as a reference, or you can give a link to that, or you can give, just keep getting that word. I wish I could remember it. How would you say it? You giving a due, Nicole, what do you
Yeah.
say? How do you give someone the appreciation, okay, appreciation or reference? There is a word for it that says that, it is borrowed from somebody's work. There is a word for it. Anyway, give them due credit. Let's just make it simple. I can't remember this. You give them due credit, okay? So that could be another way of avoiding some sort of infringement, or you can create a defense of fair use by doing that. The effect that such copying may have on potential market value of the original. Here, the fair defense, what they're referring to, can somebody tell me what it means? What it means is that there could be a depreciation or dilution of the goodwill, or branding can be disturbed, or branding can be affected, or the perception of the users may change because you have changed or given it a value which is different, or the branding has actually been affected. So you want to make sure that you are able to prove to the court that none of what you did has affected the goodwill or the good name or the intellectual property of that piece of work, because you've given due credit or whatever you've done. But most importantly, in the sense of what fair use means, there might be a question, and I keep saying that because I'm sure that there will be a question on this. And then what you have to really understand is what could be the defense of fair use. And the defense is in these 4 elements. These are not numbered, but 4 bullet points. So this is how you could defend the fair use. Test for fair use is another portion which you may want to consider as important for the exam. The fair use test requires an assessment of all factors together. There will be no bright line, for example, the Supreme Court state. Now, as an example, the Supreme Court has stated, yes, if there's a question, I'll be happy to answer. Okay, Nicole, bye-bye. Have a nice evening. Thank you for attending. See you. The more transformative the secondary use, the less likely it is that secondary use. So, just read this one as all I can suggest. Trademark is another important area. We're going to take another 15 minutes and then we'll get done with IP, intellectual property. So trademark is another type of IP, intellectual property, which is contested and defended and actually given a lot of weightage, especially when it comes to branding, and where the goodwill is involved, where the name or reputation of a company is involved, because branding or trademark is what is identified with the product. Obviously that is out there, including services. So services can be like ADP, for example, have a lot of services, including courses that they provide. There's teaching services involved, other type of services that use a trademark to be identified with ADP. So there could be, certain certifications they offer, which carries a name of ADP as a brand name, even though it is not ADP, but it says ADP certification CBC or whatever they have. So the trademark plays a great deal of part in situations where you have borrowed an image or you have borrowed a logo somewhere, or where the IP is for the textual part or the name itself that uses alphabets and characters. So this is where the trademark is be considered as. And by the way, if you get into a trademark issue, it is very expensive to defend. Most expensive lawyers are those of intellectual property defense. More of the cases are filed for trademark infringement these days, especially in North America. So what is now, we don't have to worry about the trademark law. We know what trademark is. I've shown you the two types of trademark. One has to do with the image or the artwork or the logos, and the other one is to do with the wordings or the set of words, or even the phrases or long phrases. Trademark infringement occurs when the holder of one trademark claims that another is using a confusingly similar mark. Confusingly similar is the most important litmus test, which means in the eyes of a common consumer, they should not make any mistake between one brand or the other, even if both brands are named differently, but just the image of it or the way that the logos are designed or even the colors that are used sort of give a notion or gives or blurs the distinction between two types of products or two types of businesses. This is most important. Second importance is that of damages. Has there been any damages caused because of that trademark infringement? For example, was there a website that has a logo or similar look and feel, and also confusing for the users to actually end up going on another website instead of going to the original one? So there is this problem of how the transactions or how the customers or how the public was actually going to the wrong website, and they resulted in a business loss. So one has to prove the damages also in trademark, which has to be tangible, or at least it can even give rise to punitive damages, which means that it is not only the physical damage of what the business was lost or how the consumers were redirected to another website, being confused, thinking that it is the same website, but also you have to have something that says that because of that they have lost the reputation or the products were similar but not the same. So the punitive could be a branding issue, which means that it cannot be actually been quantified, but it is something which can be assessed based on the volume of sales of whoever the defendant is. So, the claim can be on that individual who has infringed, or it could be a business. But the factors which determine if there has been a trademark infringement, similar to the copyright infringements, we have to look at all these bullet points in order for us to assess and for us to answer the question in the exam that says, for instance, in the copyrights, you have to prove or to give some sort of answer that says that these are the elements which were which actually defines or identifies infringements of copyrights. Similarly, in trademark, these points which I'm showing you right now are the ones that defines the trademark infringements. So these, what are these elements? The similarity in overall impression created by the two marks. When they say mark, it means trademarks. It's just a short form. Trademarks. Okay, so let's just say that these are the design of the logos, similarities of the goods and services involved. And the second thing, or third thing rather, which I forgot to mention, which results in trademark infringement, is the nature of the business. If the two businesses are using similar logos or similar type of trademarks, yet they are in totally different set of businesses, like one is let's say is selling shoes, the other business is selling services which don't complement each other, which are totally distinct and separate, like the other one could be a law firm. So both law firm and a shoe company cannot be compared and cannot be contested for brand infringement unless there is a way to prove that it is distinctly similar or it is totally similar, or those trademarks can actually confuse the consumers. If those conditions are not met, it is very difficult to go and prosecute or file a claim in trademark court. Okay, let's look at other elements. So similarity of goods and services is one. The strength of the plaintiff's mark. Strength means that how long that mark has been around. Do the public or is the public well aware of those marks, or if those marks have been used far before, like maybe 20 years, 10 years ago, when the new trademark, on the other hand, that is registered by another party, is very recent, even though it is approved by international organizations, or as I mentioned to you, by WIPO. It is registered there, but because the other party had been using it, but it is not a registered trademark, but been using it for 20 years, and consumer can make a fair judgment in recognizing the two as one, being there for so long that people have now have created, or they in their heads or in their understanding, they recognize it as a brand. Then there would be a contest, and those who have had a considerable following for that unregistered trademark for many years before would be considered favorable, for the judge to decide on whether the other one, even though registered trademark is there, but may not be considered to be, or may not be eligible for use. So if you see what I'm talking about, so on one hand you have unregistered trademarks, which means it has not been filed, it has not been properly registered by in the, in the databases that are out there, which enforce or ensure that you have a property or intellectual property in trademark. So even if it is not there, and because of the time, it has been around for many more years than the other brand which recently got registered, which was actually filed, then the brand which has been there for a longer period of time, which more people recognize, will have a favorable outcome as being recognized as as a trademark, as opposed to the other one, which is new one, for which people don't have that much awareness. Even though all the legalities have been completed, it has been filed properly and documents are there. But this is where the consideration is different from any other intellectual property. So this is what I'm trying to explain. The intent of the defendant in adopting its trademark, of course, intent is always important, and it has to be defined and proved, even if somebody makes a mistake or unintentional trademark infringement has happened, whereas the defendant, for instance, did not have the intent to deceive someone, or wasn't aware that another trademark existed which is similar, then the intent of the defendant will have to be clarified, and it would go in the favor of the defendant. The physical proximity of the goods in the retail market, which means that it is a goods or services which the consumers can identify with by actually picking it up in their hand, or if it is on the web, is it the goods that the user would have to know distinctly as something that can be easily differentiated from another business that is using a similar trademark. For instance, if somebody is taking CIRS course versus somebody is buying a product which has CIRS branding on it, the consumer would have easy access to the branding. If it is a brand of shoes, they would be able to make a distinction between another CIRS word used with reference to the course, because they both don't have the similarities, and because for both purchases, the consumers would have totally separate needs, and they would be able to distinguish by picking it in the hand, looking at it. Similarly, CIRS is educational. It has nothing to do with the shoes and so on. The degree of care likely to be exercised by consumer, the likelihood of expansion of the, we have to keep moving. You can read through it more if you like. Trademark infringement on the internet. Domain names can be trademarked. Then there are types of trademark infringements, such as when a person registered domain name. When you are using, when see it happens a lot. Typo spotting is something which causes confusion just because one of the words or one of the characters in the whole name, especially in the domains, is little bit different. When you look at the website that are doing phishing, like PayPal accounts asking you to put your information there, and they come to you as an email. Click on it, go to the website, you could see that the domain name looks similar to the original domain name of PayPal, which is, you know, the way that they do typo spotting. Then there is cyber squatting, which means that some people actually buy a lot of popular names or similar names, domain names, which has to do, for instance, with Coke, Coca-Cola, Coca, and then, you know, Dash and Cola and all that. But they keep buying those domains so that they can later sell it, or they can control the market, or they come in the market first and buy those names even before the big companies are able to purchase it. Or they buy certain domain names which have different extensions and they appear to look same, like you know, google.com Chrome for browser, or something which you know, is available, or a web search will reveal and bring so many other opportunities for similar names that actually belong to the major brands, and people buy that and then later sell it. Hijacking happens when you, again, going back to the PayPal, when you click on that link which says that you know, it's coming from PayPal, or that email looks and feels like it is coming from PayPal, even the logos are the same. But when you go to the website, you see that the outline or everything looks similar to what the original site would look like. My bank, TD Canada, for instance, I've made a mistake once clicking on something that took me to the web page, which looked exactly the same as the original TD Bank, where I'm used to going and logging in and putting my login information. So all those simulated websites or pages that are created similar to major brands are page jacking. Linking, we have already learned, where linking means, in this case, linking, why they're linking means sites can infringe trademark if they are selected by icons that in. If I'm using, let's say, in my website, I use certain brand names as if they're my affiliates or I'm authorized distributors, like major brand names like Cisco Systems or you know, Amazon.com and all their branding names, and then behind it is a clickable link. When somebody clicks on it, it takes me to another website which is not exactly Amazon, but it could be phishing site again, and it could be taking me to the page jacking site. So that is the linking or deep linking we've learned earlier. Framing is presenting in the same sense, in the same way as I explained before. It is part of how you would be uh, using or infringing the copyrights by making something appear on your website. Trademark is used in the same sense, where the trademarks or the captions or anything that is an intellectual property generally is appearing on your website, or it is being played on your website. Meta tags and hidden tags. It's similar to what I explained to you about anchor link, which means it is going to say something in words, but it is a hyperlink. Behind that, there is a link. If you click on those wordings, it would take you to another website. So those are hidden text or meta tags. Let's not worry about meta tags. Let's think of it as hidden text. Meta tags becomes more technical. Trademark dilution is very important for you to identify with as something that has to be proven in the court of law, and therefore would result in very hefty damages, which means that they don't have to be exactly quantified, or they cannot be quantified, but dilution means that it has affected or tarnished the reputation or the reputation of your mark, where people have used those products thinking that it is of the same quality which the brand represents, but turns out to be something different or slightly different. So that creates a dilution of goodwill, and that could result in a lot of money or damages money, I guess, that one can claim. The types of trademark dilution can be blurring. These are one of the types. This happens when the power of the mark is weakened through its identification with dissimilar goods. Which means that a branding which is Nike, for instance, if Nike tomorrow starts making cups and utensils, or if they get into that business, then of course Nike is a brand that would work nicely for any of the products that they're floating or they're bringing out. But supposing Nike is a brand which is exclusively for shoes, and then somebody else starts to create some other products which has nothing to do with the shoes, yet the image of Nike or the sign of Nike or whatever that is considered to be a branding, particularly a trademark, is being used in other type of goods, that would create a blurring of reputation or blurring of trademark. Tarnishing is actually creating or bringing any goods that are of low quality, that is you start selling, which is the worst form of trademark infringements, and you would end up paying a lot of money for it. For patents, there is not much that I can talk about. Patent is very technical area. What technical means that these are the set of first of all, it is very hard to get the patents. The more difficult the intellectual property registration, the more difficult for others to copy it. So patent is one thing which is not easy to be copied, and even if somebody copies it, for anyone whose patent is copied, they can easily prosecute that person or bring that person to the court and win easily, because the patents are searched extensively, and a lot of time is taken by the patent registration agencies to actually accept that patent by going through all the details, all the designs, processes, methods, everything that has to do with the patenting of a product or patenting of an idea, because ideas can be patented also, but they have to be expressed in writing, or they have to have some sort of design or a method or process involved that makes it look like as if it is an intellectual property, meaning that it has to be tangible. You can see it, or you can feel it, or you can hold it. So those are all patents, and requirements of patentability is given in this chart. There are not a lot of questions in the exams, but I would say that at least you should be able to know what is patentable and what is not patentable. So between these two, you may want to look at this chart. Patent infringement, you don't have to worry about. Doesn't happen much, and even if it does, it is a win-win for whoever patent has been copied. Online privacy, defamation, and spamming we will cover tomorrow, along with the ethics or ethical issues of human subject. That is what we are going to cover tomorrow. Not a lot left, so by tomorrow we should be able to finish the entire lectures of CIRS course that you signed for. And after that, we will see what I can suggest to you to pass your CIRS, and explain to you what the association would be able to do to assist you or guide you further in giving your exams. So with this, I'm just going to conclude today's lecture. Unless there is any questions, we will just sort of call it a day and go grab something to eat, take a rest. Any questions so far, Tammy or Aaron?
No, I'm good.
I just let
And
you know.
I will be attending the class tomorrow. I told you I wasn't going to be able to, but my appointment was canceled, so I will be
Okay, that's
attending
good.
tomorrow. Yeah.
That's a good news, because we are down by one person or two people today. There was another person. Her name is Tioni. She was supposed to join us because she missed her 2 classes from the previous session we had for CIRS. So she didn't show up, and then Melanie wasn't available and so on. So I'm glad you will be there. Otherwise, it's just going to be me and Aaron, or Nicole is going to be around, but she's going to leave early as usual. She leaves exactly at 6 o'clock is what I've noticed. I'm sorry, at 8 o'clock, exactly at 8 o'clock. So anyway, thank you so much. Have
Hello?
a great evening. Enjoy. And
Hello?
yes. Did you have a question, Aaron? Anything you wanted to
Yes,
ask?
I'd like to
Go ahead.
ask, do you need liability insurance? Or if you do, what type of, how much would you carry if you know?
For the research business?
Yeah. Because it seems like you can sometimes be sued.
Correct. Well, the insurance you carry is the liability insurance. The coverage depends on the type of liability that you want the agencies to cover. For instance, we have a liability insurance for the board of directors or the directors, because this is a whole package. You don't get it like separately. So we got directors liability, we got business liability, we got tax, in case if there's not enough money in the bank or something. So we got that covered. Then as far as the work, deliverables, research and all that, that is the entire liability for the business or somebody sues the business. I think for the board of directors or individually, they have about 1 million each. So we have 4 people, so there's 4 million. And I'm going to give you the figure of what we pay for it. So I cannot say exactly, but all I'm going to tell you is that we end up paying X amount of money. Okay, you too,
All right.
Tammy. Goodbye. I'll talk to Aaron. Just answer his question. Bye bye. So we got 4 million there, and
No, I just want to know, because it seems
5
like
million.
in the business, it's possible for you to be sued. So that's why I was wondering, is there any type of liability that you could carry individually?
Business liability.
Okay. All right.
So the business liability together, in our case, I think we end up paying about 16,000 a year.
Okay. All right. That's good enough. I'll check it out.
Yeah, I think in small businesses, I don't have. I mean, we are small also, but about 16 to 20,000 for the whole year. But if we don't include the board of directors, I bet you it's going to be like about close to 10,000 in Canada. Canada is expensive, in Canada, the insurances are very high.
Okay.
Just for the motor vehicle, you won't believe the insurances we have to pay. Compared to you guys, it's pennies and dimes for you. We pay a
Okay.
lot more.
Okay.
So,
Okay. Thank you, Mr. Mensah.
all right, you take care, Aaron. I'll see
Yeah.
you tomorrow.
Okay.
Okay. Bye bye.
Good night.
Good night to you.